Good afternoon, ladies and gentlemen. I'm Jack Whelan. I'm the District Attorney here in Delaware County, and I stand here today with our Senior Deputy District Attorney, Daniel McDevitt, and Assistant District Attorney, Bill Toal III, as well as the Chief of the Criminal Investigation Division, Joe Ryan. We announced today the long-anticipated opinion by the Honorable Frank T. Hazel in the case Commonwealth versus Arthur Bomar. I stand today with Dan, who was the trial attorney for our office, and Bill Toal, who has handled all of the appeals filed since the defendant, since his trial back in 1998. It was almost 14 years ago to the day the jury selection began by Dan, and on October 1st, 1998, a jury in Delaware County convicted Arthur Bomar of first-degree murder, kidnapping, rape, abuse of corpse, and aggravated assault for the brutal killing of Amy Willard, which occurred on June 19th to the 20th of 1996. Amy Willard was the daughter of Gail Willard and former Chester City police officer Paul Willard. She was a star lacrosse player at George Mason University at the time of her death. Bomar was formally sentenced to death on October 5th, 1998. This opinion is important because Judge Hazel has made factual determinations, and it will make it much more difficult for the defendant to gain relief in any type of future forum. This is a death penalty case. We have been willing to pursue the death penalty because of its heinous nature of the defendant's action and the defendant's significant prior violent criminal history, including murder. During the penalty phase of the trial, we presented 3 aggravating circumstances to warrant the death penalty in this particular case: a prior murder and a 1979 conviction, significant history of convictions for violence, specifically in 1979, a conviction for aggravated assault as a prisoner while he was inmate in the state of Nevada. And in Amy Willard's case, the defendant committed murder during the course of a felony, kidnapping, and rape. Arthur Bomar represents every parent's worst nightmare. He took from 2 devoted parents a child who was loving and was loved by her family, her friends, and her peers. Amy was a star athlete who had a bright future, which was violently ended by this heinous criminal defendant, Arthur Bomar. I'm going to now turn the microphone over to Assistant District Attorney Bill Toal to comment on the appellate process and what this opinion formally means. Bill?
Thank you, Mr. Whelan. Today's opinion is important for a number of reasons. First, it represents not the end of the process, but the next step in the process. Having been sentenced to death, it's not unexpected that he has filed appeals and continues to do so. They've already filed an appeal to the state Supreme Court, and the next stop or step along the way will be with the state Supreme Court. The defendant will have an opportunity to file a brief to which the Commonwealth will respond, and then if we are successful, it would not be beyond question or wouldn't be unusual for them to proceed to try to get relief in federal court. One of the reasons why today's opinion is as important as we've said it is because Judge Hazel has made factual determinations and explained his conclusions of law in a way which will make it much more difficult for Mr. Bomar to gain relief in any subsequent proceedings. His factual and credibility determinations have gone in favor of the Commonwealth's witnesses and against the claims of Mr. Bomar and his lawyers and witnesses. There were lots of allegations of whether it was prosecutorial misconduct, improper testing of the DNA evidence. There were claims that the jury had interacted with the Sheriff's Department in inappropriate ways, and each of these claims has been specifically rejected and refuted by the Commonwealth, and now those refutations and those determinations by the trial court and the PCRA court, Judge Hazel, have gone in the Commonwealth's favor. So these are going to make it much more difficult for Mr. Bomar to find any possibility of success in future proceedings. As I said, this is probably not the end of the road, but it's certainly a significant step towards carrying out the verdict which the jury found some 14 years ago.
Open it up for questions.
Have you had any contact with the family since this has come out?
I spoke with Paul Willard today, and I think we left a message for Mrs. Willard.
Yeah, we left a message for Gail Willard today, but they certainly knew about the order denying the defendant's PCRA petition several months ago, and we notified them again recently that this opinion would be coming out shortly.
Yeah, the judge actually denied in a very short order the claims in March. But today's opinion, 213 pages, is important because it actually gives the explanation for how he came about making his determinations and the legal reasoning behind his decision to deny relief.
Did the family have any, what did the father's Paul say? What did he say?
Pleased to be, pleased to be alerted, pleased to be informed, pleased with the result. Clearly, he understands that this is not the likely end of the process.
Can you mention again some of the claims that Bomar made?
In this, there were over 20 separate claims. A lot of them had to do with claims of ineffective assistance of counsel, but there were also claims that had to do with such things as allegations of inappropriate contact between the some people in the sheriff's office and jurors. There were allegations that the DNA evidence was not either properly handled or that it was not as we claimed it to be. There were claims concerning like that the jury was not properly picked. There were claims that trial counsel did not do an effective job in representing Mr. Bomar. You name it, they claimed it. There were 20 claims, each of which had several subclaims, and that's why you see 213 pages to explain some of the allegations that were raised.
There was another phase of appeals, though, before this.
Yes. Immediately following trial, at that time in the process, we had what were called post-sentence motions. And post-sentence motions allowed the defense to raise certain claims, including some ineffective assistance claims, immediately after trial and before they did sentencing. Since that time, the process has changed, and actually the case Commonwealth versus Bomar is now one of the cases that is often cited in legal briefs for the proposition that you're allowed to raise certain types of claims if you present them to the trial court in post-sentence motions, that you don't have to wait until appeal. So after that, we had the direct appeal process. So that went to the state Supreme Court. The U.S. Supreme Court denied certiorari, so they denied the request to hear it. And then it came back, and they filed in 2006, they filed a PCRA claim. We had initially a competence evaluation, because to your question, one of the other claims that they alleged was that he wasn't competent to stand trial, wasn't competent to participate in the hearings, and that was addressed in 2007. So from 2006 was the initial filing of their PCRA petition, for which today is kind of the last piece of the last part of the process in the Court of Common Pleas. Now it'll go to the state Supreme Court. But as I say, we're not anticipating that that's the end of the road, but it's certainly a significant step towards carrying out the jury's verdict in this matter.
You said state Supreme Court, you said?
Yes, the state Supreme Court. They have filed a notice of appeal to the state Supreme Court.
What are the grounds for that?
Pretty much everything that they've addressed, yes. So yeah, direct appeal was denied. They did gain some measure of relief. Notice that the state Supreme Court initially upheld the death penalty, but remanded for resentencing on some of the non-death penalty issues. So we had another sentencing hearing, and at that time, the judge basically reimposed the same sentence that he imposed previously. So then there was another appeal from that. So the appeals process went up until about 2005 or 6, and then they filed what's called a Post-Conviction Relief Act petition, and that's what we are addressing today. The judge has denied all their Post-Conviction Relief Act claims.
Bill, you kind of touched on this, but in terms of the type of reassurance that this offers the family, talk a little bit about that.
Well, it's the kind of thing where We knew that in March, when the judge decided and ruled against their claims, that we had successfully met our burden in terms, or the defense had not met their burden, and we had prevailed in connection with the outcome. But what today does is provides the factual determinations that are going to be very important for any subsequent court proceeding. The state Supreme Court initially, and if they then try to pursue if we're successful then, and they try to pursue anything in federal court, that means that we won't be revisiting some of these factual determinations. In other words, in some of the claims that they made allegations that our office had an undisclosed deal with certain witnesses. All right? The judge found that that didn't happen, that was not true. That our witnesses who said that didn't happen were credible. Therefore, in any subsequent proceedings, they don't get to revisit, they don't get a do-over or a redo as far as whether or not that witness or those facts should be revisited, and should we believe it or should we not believe it. The record in this case shows that those allegations were not credible. And so there's a whole host of issues for which the court had to make credibility determinations and also specific factual findings. All of those went pretty much in the Commonwealth's favor, which will now make it much more difficult for the petitioner, Mr. Bomar, and his lawyers to gain relief down the road, because they have to live with and basically accept those factual findings going forward. So their legal issues that they might be able to try to appeal are going to be tougher for them to do so. And that, I guess what you were asking is, I mean, that's comforting in terms of being able to know that it's harder for the defense to win going forward.
So if all that stuff is basically off the table as an appealable issue, what can they appeal on?
Well, there's nothing. I mean, you can't stop them from appealing things. What they're basically going to do is say either that Judge Hazel was wrong, or that the record doesn't support some of his findings, or that there's some other principle of law that ought to apply. So I'm not suggesting that they're not going to try to do something along those lines. I'm suggesting that Judge Hazel, in a thorough, detailed, and very comprehensive opinion, has made it much more difficult for counsel for Mr. Bomar to likely succeed, because he has addressed all the kinds of concerns that were raised here, which will make it much more difficult for them to try to do something down the road. It's the kind of thing where if the judge didn't address it in this kind of detail, or left some things unaddressed or unstated, they might have the opportunity to try to have another evidentiary hearing, either in federal court or have it remanded or something else. But his thorough and detailed opinion means that it's less likely that they will, be able to be successful in the event that they do.
It's certainly important for our office. We knew Paul Willard, who's a police officer in the city of Chester. Bill Toal worked with Paul Willard as a police officer in the city of Chester, who was assigned to Chester District Court. And I personally worked with Paul Willard in the city of Chester when I was assigned to the city of Chester as an assistant district attorney. So this certainly rings home and is important to the office of the district attorney. Dan and Bill just did a tremendous job. It's important not only to convict them, but to keep them in jail. This is one very dangerous individual that has killed multiple times in the city of Philadelphia, here in Delaware County, and is even suspected of other killings. So I say to you that this is one individual that certainly deserves the death penalty, and that's why we pursued it.
Do you know who his attorney is these days?
Excuse me?
Do you know who Bomar's attorney is?
His attorneys for all of the Post-Conviction Relief Act litigation have been the Federal Defender Capital Habeas Unit. Michael Wiseman, who is no longer with that office, a fellow named Leora Bellino, and Jennifer Chicarina, among others.
So it's the Federal Defender Capital
Federal Defender Capital Habeas Unit.
Habeas?
Habeas, Habeas.
Any other questions? Thank you.
We thank you for coming.
Yeah, well, will you be available if we have a question after reading part of this?
Yeah, it's